Hi, Facebook. I'm going live today, so you get me an extra time this week. I usually go live on Mondays at 10, but since the lockdown, we've also been doing a longer live every fortnight on a Friday, and that's been alternating through all the staff. So today you get me again. So for those who don't know me, my name's Jackie, and because it is Halloween tomorrow, I thought that the theme today could be horror stories, because lots of people have horror stories about all sorts of legal matters, but I'm going to go through some of the more recent cases that have been in the Supreme Court in Victoria about will disputes. So that, because there are a lot of myths and people talk about their own, friends of a friend who's gone through a dispute, but you don't necessarily know exactly what happened, and most of those probably actually didn't get to a court judgment. Most of them probably settle. So these are actually court judgments on estate disputes that have gone to the Supreme Court and had a judgment. So I've got a whole paper on a lot of updated cases from the last couple of years, particularly judgments coming out this year. So let's have a look. So this first case came out. Initially, it was actually a court of appeal case. So initially, the judgment came out last year, and then it went to the Court of Appeal this year. So quite a big deal to get it to appeal as well. So, I mean, in terms of horror stories, these guys have spent a hell of a lot on legal fees. And this case is about who is a domestic partner or a de facto partner. So a spouse and children are generally categories where people are allowed to make a claim. A spouse can be someone who's married, and obviously a de facto. In this case, the woman who brought the claim was a former they all agreed she was a former domestic partner, so former de facto. She said that the relationship had been on and off for about 40 years. So the fellow who passed away and this woman who made the claim met in 1977. They moved in together about that time and had a child in 1980. And they started living in this property in Albion with the deceased guy's parents. They moved to Serbia together as a family with their child in 1984 and then came back to Australia in 1987. They had bought 2 houses together over the period they lived together, both of which she said that they ended up losing to the banks because she said that he gambled a lot and drank heavily. She also claimed he was violent. They finally separated in about 2016 or 2017. She had an intervention order against him at about that time. The brother was the person who was actually left everything under the will. So he had left out this woman and he'd left out his own child too. So the brother said, no, they broke up in 1997, so a long time ago, the brother said, and that she had had a housing commission house since that time and had been claiming Centrelink benefits as a single mum since that time. So it was denied that the relationship was as recent as it was. So the property in Albion where they'd originally lived together as a couple with his parents early on in the relationship. He then inherited after his parents had both passed away, but he inherited it in about 2016 or 2017 after they'd separated. So there was a number of issues. The issues were whether the relationship went up as late as it was, because a former domestic partner usually only has a claim if it's within a certain period of time. And it was found that they were in a relationship up until September 2016. There was advice given to some of the parties by lawyers in this that because he'd inherited the property after they'd separated, she wouldn't have a claim on it under the family law, which was incorrect advice. So so the house was valued about $700,000. So instead of the brother getting it all, there was actually a payment award ordered that the domestic partner, so the woman, gets $550,000 out of the $700,000. So it was actually quite a successful claim that she made. Now, so that was the judgment from last year. The brother then appealed that and went to the Court of Appeal this year. And so we've now got a further judgment. And the Court of Appeal basically dismissed the brother's claims to the Court of Appeal. They confirmed that she was an eligible person. They confirmed that it was misconceived advice, that the family law didn't allow for a claim on property acquired after a separation. And they went through all the evidence again, and again there was some questions around the reliability of the woman's testimony. But the thing is, there was this child as well of the relationship, and so the woman and the brother were both found to be not very credible and having a lot of emotional angst around the decision. But the daughter, I think it was the child, was fairly neutral, and so a lot of the weight ended up being put onto the child's evidence. So yeah, the judgment was held. So out of a $700,000 estate, to go all the way to trial and then all the way through appeal, I don't know that there would be all that much left. So that's part of the horror story. But in a way, she was vindicated because it's confirmed that she did have a claim. She was eligible as a former de facto partner. And it also went to show as well about the reliability of people's memories, how they provide their evidence based on the outcome that they're trying to achieve, and the fact that the judge really had to rely on someone who was fairly independent in the end. So, interesting case. Another one, the judgment came out towards the end of last year. Again, a domestic partner made a claim, and in this case it was actually dismissed. So this was a young woman who passed away, and she passed away without a will. She had no children, and her parents applied for letters of administration under intestacy. If you pass away with no spouse and no children, it all goes to your parents if they're still alive. So they applied. Then this fellow pops up and makes a claim saying that he was a de facto partner. And in fact, it was dismissed. So he didn't meet the 2-year requirement to cross the line as a de facto. They had lived together for a period of time, but certainly not for 2 years. and he didn't establish that the relationship was strong enough to warrant as a de facto. So it's quite an interesting case into what they looked at as to what would warrant being a de facto relationship. So they talked about when they were living separately, how often they stayed over with each other, how much free time they spent with each other, whether they declared their love for each other or not, whether they were hosting dinners and associating with friends or family to put forward their relationship, whether they were planning holidays together, whether they were planning to invest and build a house together. So there were all sorts of factors that were looked at, and then the factors that went against him were that they actually hadn't combined assets at all. They each had all their own furniture. They each had their own pets. They had no joint bank account. They had no financial interdependence at all. So it didn't warrant being a de facto relationship. So his claim was dismissed. So that horror story over and done with, I suppose, quicker than the first. The next one, again, is another de facto relationship claim. So another horror story. In this one, again, the male has passed away, and a woman has come forward saying that she was either the current de facto or former de facto. So this judgment only came out earlier this year, but I believe that he'd been passed away for some time. So the sole beneficiary of the estate was a different family member, and they said, nope, that de facto relationship finished in 2014, so they're not eligible. So it was way too long ago. This person doesn't have a claim. So again, the court looked in depth at who is eligible and who meets the requirements of a de facto. And in this one, I believe it was also successful. Again, the court had a lot of difficulty relying on the woman's evidence or the evidence of the sole beneficiary in the will, because they clearly each other wanted to win their own case. So they had to rely strongly on third-party evidence. So yeah, it was found that there was a 12-year relationship and that the relationship had gone up to all the way up to 2017, not 2014. So she was eligible to make a claim. I don't have the amount of the estate or the amount that she was awarded out of that horror story. All right, another horror story. So again, another claim against a will, and this one came out at the end of 2019, so another recent one. This one's not a de facto one though. This is a married spouse. So this is a blended family situation, which is always hard. So this case, it's a woman who's passed away. She had 5 children to her first marriage, 2 of which were already dead. So she only had 3 kids left, and she was married to her second husband. So the only asset in this estate was half of the principal place of residence that they lived together in. So her and her second husband. So in her will, she left her half to him to reside in for life, but then it was to go to her 3 kids equally once he passed away. So he didn't think this was fair. The second husband, he wanted 10 to 20% of the estate outright, And he also wanted the right to reside to actually be a flexible life interest, so that if he needed to, he could sell the house and go into aged care or something like that. So in this horror story, there's a little bit of background information, because you might initially think, oh, but you know, this woman was protecting her half and making sure that it went to her children. But in fact, the second husband had fully owned the house himself before they even met. And then in 2012, after they'd been married for a while, he put her onto the title. But we have the issue where he probably thought it was jointly owned and not tenants in common. So he said that he didn't actually understand the consequences of having her on there as tenants in common, and that she would own half to will to wherever she wanted. So it was actually his property, and he gave her half. She didn't pay for any of it. And so his claim was actually successful. He did get a lump sum, and he did get a flexible life interest out of it. So he got 20% of the estate, and the remaining 80% of her estate would go to her children once he passed away. So successful claim in that one. And in that case, I don't know where it wouldn't be successful, because he was probably asking for less than what he was entitled to, because people's first obligation are to their spouse before their children. So next one, and in the theme of keeping to horror stories for Halloween, these are recent cases that have just been before the Supreme Court in terms of will disputes. So whether these claims are successful by the person making them or not, you can understand that it'd probably be a horror story for the whole family, because of the time and the cost involved in going all the way to a trial. So this one is a claim by an adult child. And in this one, the claim was actually dismissed. So this case came out this year, and in fact, they went twice to trial, because there was the first trial which determined the actual application, and then the second trial was trying to get their costs paid. So in this one, the person passing away was survived, so the man who passed was survived by his female partner, and they'd been together for 20 years, and he also had an adult daughter from his first relationship. So the will gave her, the daughter, $50,000, and the rest went to his partner, so his de facto partner of 20 years. So that seems fair. The estate, the house was only valued about $650,000, and he had a share portfolio of about $100,000. So it's only $750,000. Now you can see going to trial has probably used up at least $100,000 of that. So $50,000 to the daughter. The daughter's not all that happy with that, so she makes a claim against the estate. A whole lot went towards a whole lot was looked at her financial position, but basically she wanted 35% of the estate, and she wanted then the partner to have a life interest only, so that she would definitely get the property at the end. But the whole thing was actually dismissed. So even though the adult child had actually quite a difficult life, so she had 2 young children, one of them was disabled, she was a single mum because she'd been divorced, she did own a house. The house was valued about $400,000, and she still had a mortgage of about $80,000. She then claimed as well that she had some medical problems of her own, but didn't provide any medical report. So she also didn't provide any evidence around any child support issues that she claimed she was having. So she was trying to say that she wasn't as well off as she appeared because she wasn't being supported to look after her children. And then the court also looked at the de facto partner's financial position. And like I said, it ended up coming out that nope, when there's a competing claim by the children from the first marriage and the second spouse, the court has recognised that it's paramount to look after the second spouse. So that was a specific quote from Her Honour. Then there was a second case about the costs, but again dismissed. So dismissed all round on that horror story. The next horror story again is another adult child. So we've done, I think, 3 de factos, we've done 1 married spouse, and now this is the second adult child case. And this came out just towards the end of 2019. So in this one, the old fellow passed away, didn't leave a spouse, so he's got 3 children. So 1 daughter and 2 sons. In the will, he divided his assets as to the daughter getting 800,000 and each of the sons getting 1.2 mil. So the daughter was getting about 400,000 less than her brothers. So clearly, the adult child who made the claim was the daughter because she didn't think that she should have gotten less than the others. And in fact, not only did she just say that she wanted a third, she wanted more than a third because she wanted a specific property and then she wanted a lump sum to be able to repair and maintain the property. This one again came down to a lot of discussion around their own financial situation. But ultimately, it also came down to the fact that the old fellow who'd passed away had actually given a substantial amount of money to the daughter while she was alive. She apparently had an accident a few years before and he'd helped her out significantly with that. So she then tried to claim as well that she had ongoing health issues from that accident, a horse riding accident. And then she also tried to substantiate that she had, because she had horses as well still, that she had significant vet and farrier expenses of about 40,000 a year. She tried to say in her, annual budget, but she didn't have any evidence about the medical conditions and she didn't provide any substantiated evidence around her ongoing costs for the horses. So some of the things that she was trying to put forward were just pretty much dismissed. But overall, her application to ask for more was dismissed as well. So the court determined, no, you've had adequate provision. You didn't get an even amount because you've already been partially provided for during your life. So there's another horror story, keeping in line of the theme for Halloween. So the last couple that I'm going to cover is one is about a farming property. Then there is a horror story about the disposal of a body. And then there's also one final horror story about an informal video will. Okay, so 3 more to go of our horror stories for Halloween. So in this will, so the old man farmer passed away, leaving 4 children. And I'll use the names that the court used because it's not private. This judgment came out this year. So there was 3 children who got very little, and the 4th child, the daughter Heather, got the majority of the estate. So Heather got close to 90% of the estate, and then the other three children, Peter, Wendy and Gail, Peter got 5%, and Wendy got close to 5% and Gail only got 0.2%. So the three children who didn't get very much made a claim. So all three of them made a claim against Heather. So the value of the estate was about $5 million. Most of it was in 2 farming properties. There was a share portfolio as well of 1.3 mil. And there was also a residential house. So to some degree, a couple of the claims were successful, slightly. So it was just tweaked to work out what the amounts actually were. So Peter's claim was the most interesting one. So I'll go through that one for you because he's the only son. And you sometimes think that sons do pretty well out of farming matters. But in this case, Peter was the eldest and he had a mild intellectual disability. He'd worked on the farm for 25 years at getting a token wage of only $3,000 per annum. So you can already see that they were starting to set this case up as, well, he got fuel in his car and he got his board free so he could live there. But you can already see that he was setting up this as, well, I worked on the farm for free for the promise that I'd get it. So mum and dad divorced in 2011 and Peter actually went to live with his mum. So the old man farmer sort of stayed by himself on the farm. He ended up inheriting his half of his mum's property along with Wendy. So him and Wendy already owned this house 50-50. He had a little bit of savings of his own. Interestingly, Wendy also had a severe cognitive disability, but she'd already had some inheritance from her mum as well. Gail was the youngest. She was living in New Zealand. She had a much more sort of ordinary life. She was a hairdresser running her own business. She had 2 young children, a house worth $250,000 with a mortgage of $100,000. So she was getting along, you know, modestly. But there was also Heather, who'd got the most. She'd returned actually to live with her father with her partner. There was no children, but they were farming the property. So as well as the 2 bits of farming land and the share portfolio, there was also this residential house. So this house was actually bought for Peter to live in. And Peter was supposed to be paying $120 a week to pay off the house, and then that house was going to be transferred to him on the death of his father. So his father had tried to help him out during his life. But Peter decided not to pay the rent. So he hadn't been living up to his part of the deal. It had been fairly consistent over the last 10 years that it was the farmer's wish that Heather have most of the estate. So in this horror story, Peter also was accused of drinking heavily and not coming along to family events, being estranged, embarrassing his father, starting to get violent. And so there was all this other information coming out in the background. So Peter actually wanted that house transferred to him, which was the original promise, but Peter hadn't lived up to his promise, so the court didn't transfer that house to him. He got a flexible life interest in the house, so that means that he could not have to live in that house only. He could sell it and move to other houses if he wanted to, or use the money for whatever else he wanted. But then the balance also was held on trust for him because he had this drinking problem, and it became quite apparent. So there's a horror story in terms of a farming matter, which is not your usual straightforward farming matter. It was quite a more complex case because of the dynamics and the lifestyle of the children. And overall, a fairly unsuccessful claim by those 3 children. So Heather still got the majority. She certainly kept the farm together. 2 more horror stories to go. So this one is about the disposal of a body, and this judgment came out in 2020. And in fact, it was the second time they'd been to court, which was really quite ridiculous. So this is sort of early on in the administration of an estate. The executors are the ones who are supposed to organise for the funeral and the burial or the cremation of the body. In this case, there were 5 kids. 2 of the kids were executors, and these 2 just could not get along. So they'd already been to court once, and there was orders made about various elements of the funeral and the burial arrangements, and there was an order that each party was supposed to bear their own costs of dealing with it and organising it, because they had spent so much money already going to court to get this order in the first place. And the estate hasn't even really started. We've still got a body that's not buried, a funeral that hasn't happened, and the estate hasn't been started being administered. So this judgment was one of the 2 executors went back to court again because they couldn't agree as to what the costs were that they were to bear their own. So they again went back to court. Now, the court was not very happy with this, not very happy that the executors couldn't work things out between themselves, thought it was quite ridiculous, not very happy with the lawyers acting for these 2 because they thought you shouldn't be allowing this to happen. This should not come back to the court. The court's job is not to work out cost disputes between executors over a funeral. So the court actually punished the executor that brought this case back to court because their behaviour was unreasonable, and it was described as unreasonable contact, and so the person who brought it back to court actually then had an order against them to pay all the costs. So they got a penalty. So, I mean, that's just a horrible horror story in terms of that family. You've got these other 3 kids sitting in the background, just sort of in between these 2 executors. Their parent is still not buried. Just sometimes what goes on. Final horror story for you for Halloween. So, again, a dispute over a will. And this was in the Supreme Court this year, so the judgment has only just come out. And I don't have the full background on this one because it sounds quite interesting. There is 3 children in this one, and mum passes away. Her will was all the way back in 1986. And probate on that was given to the executor, one of the daughters, in 2015. So it's sort of done and dusted. And I don't know why it took so long for the estate to be wound up. But basically in December of last year, the son then makes an application to the court saying, no, that 1986 will shouldn't have been given probate. There was a video recording I made of mum in 2014, just weeks before she died, which should be her will. So I don't know why he took 4 years to bring this forward. But it was quite an interesting analysis of whether this video would constitute a will or not. And basically it would have, except for some issues with it. So yes, a video of someone making a will is considered a document for the purposes of having a recording or a will documented. And it also made it clear that this video was made as a testamentary intention. So in the video, she was talking about her wishes when she died. What she didn't do in the will was confirm that she wanted this video to be her will. And she also said at the end of the video that, we should get a solicitor in to have this will done properly. So she'd already indicated that there were some issues with it. But the main issue with this video recording was that it wasn't a complete recording of the whole thing. So this son had edited it. So there were sections missing and it jumped a little bit. And so because it wasn't complete and there were the gaps in the recording, it was quite problematic. There was suggestions that the son had been coaching her and had then edited the coaching out of the video. But without the full video, it just couldn't be determined. So he sort of shot himself in his foot, but I don't know what they were thinking there to take 4 years to bring this video forward, and then for the thing to have been heavily edited anyway. So it was dismissed. So the 1986 will was upheld. And again, just another horror story because a family has been dragged through all the way to a trial. It's hard enough when a family is dragged through a dispute all the way to mediation and it settles. Yet in these ones, they've gone all the way to trial. And not only then do you see that even when an application is successful, you see that the person feels like, yes, they've won. The other family members will feel like they've lost. But ultimately, because it has dragged on for so long, quite often people are so exhausted that no one feels like they've won anything. And to get to trial, like I said earlier, has probably cost the estate at least $100,000. So horror stories for Halloween, there you go. So this live video, like I said, every fortnight on a Friday, we try and do a longer form live for you with a bit more detailed information. So I will save this onto the page so you can go back and zoom through the various horror stories that I put in it. So they're all claims against wills. The first 3 were de facto spouses. There was one there from a second marriage, blended family, and there were 2 adult children claims, and then there was the family farming claim. So all of those in there. I hope that it gives you some stories. A lot of people's horror stories and myths about will disputes of a friend of a friend. These ones have actually been through the Supreme Court. So I hope everyone has a great weekend. I hope you have a happy Halloween if you celebrate that. And otherwise, I'm live in Facebook every Monday morning with a short snippet of legal information, but you can catch us, like I said, on a Friday every fortnight doing a longer one. All the videos are saved to the page, so you can go back and have a look through those to see what's relevant for you, or forward anything on to someone else that would be important for them. So thanks for those who've jumped in and out to watch live. Like I said, hope you have a great weekend. Catch you next time.